Once I get the notification, we will start. Good evening, good evening, good evening, everybody. Dallas, really, right as I start, guys, people in Instagram and YouTube know what's going on. Some people in Facebook know what's going on. But for you new people, hi, King Tax Services 18. How are you, my dear? Hello, Facebook. Happy Thursday, guys. Happy Thursday. If this is your first time in my live stream, hello, Foreclosure Defenders. My name is Natalie Pierre-Lewis. I'm the owner and operator of NPL Consulting, LLC, a business formation firm. What that means is I help you get your business paperwork together. So things like getting an EIN number, filing your articles of incorporation with the state, having appropriate contracts, trademarking your work, protecting your intellectual property, keeping you from being sued for using people's intellectual property. I help you do all of that. Hello, Ivana9572. You may be asking why I'm qualified to help you with all of that. Well, I'm very glad that you asked. I have been a licensed attorney for over a decade. I have started multiple businesses for myself and others. I had my own pet services business from 2009 to 2012 that is still in operation, being run by my old business partner. I have worked with several social media influencers and helping them get their legal stuff straight. And most important, I am very passionate about making business and legal education as accessible to everybody as possible. Not everybody has the time, money, or desire to go to business school or law school, but so many of you out here, you have amazing business ideas, and it's time that the world knew about them. And that's what I'm here to do. I'm helping you to facilitate getting that done. Okay. If you are interested in any of those services, you can check out the link in my bio, linktree/NPL consulting firm, linktree/NPL consulting firm, linktree/NPL consulting firm. There you're going to find access to my free trademark toolkit that's going to give you tips and tricks to protect your work in the marketplace. You're also going to find access to my Protect Your Biz video training. So many of you, I get a lot of questions about, how do I protect my work? How do I copyright? How do I trademark? Guys, hold on one second. You are incorrigible. My dog was chewing my remote. Yes. So many of you have questions about those. The Protect Your Biz webinar is a 2-hour or video training. It's a 2-hour video where I explain the basics of copyrights, patents, and trademarks. The bundle is available for $79. Hello, Miss Whitney, in the store. But I have a special deal for you guys who are in the live stream today. If you are in the live stream today and you DM me your email address, you can get the Protect Your Biz video training for just $35 instead of the regular $79, okay? But enough of that. We're going to get to those questions in a moment. And of that, I want you to explain why I get on here every Thursday. Every Thursday, if you're new, I get on here and I pick stories from the news that are popular, that Foreclosure Defenders, I'm going to get to your questions in just a moment. I pick stories that are popular in the news that demonstrate business issues, business concepts that I think are important for entrepreneurs to know. And I, inject a little bit of fun and we talk about them. I have talked about celebrities like Cardi B, Beyonce, big companies today. We're talking about some big companies today. I talk about Apple a lot. Who else? It's a fun time. But this is also a time for you guys to learn how trademarking, copywriting, patenting, contracts, how the businesses work, the infrastructure of business. It's fun, when you see the Instagram posts and, the videos and Instagram stories and things like that of people running their businesses, or you see the commercials, but there are basic concepts that every business has to go through, no matter what it is. And no matter how fun or how boring it seems. All businesses pretty much start off the same. And that is what this live stream is about, is to help you guys understand the basic business concepts that you're going to come across as a business owner. All right. So if you do have any questions, please feel free to drop them in the comments. As well, if you are watching the replay of this, I have just started something new called Chat with Nat, where every Tuesday I'm going to respond to your questions. So if you don't have a chance to watch this live, or if you have a question that you didn't want to ask in the live, you can email me and I will answer your questions on Tuesday in a video, and I'll post it across all of my social media. So check out, you can email me at nplconsultingfirm@gmail.com, nplconsultingfirm@gmail.com, nplconsultingfirm@gmail.com. And it doesn't just have to be questions. If you have comments about stories, if you were thinking about something and you come across it, I want to hear from you, and I want to, interact with you as best I can on here. So I want you guys to participate in Chat with Nat as much as possible, and I will be reminding you of that throughout the week. Okay? So, thank you. I didn't think of it. Somebody else thought of it. Brittany Reese thought of it, my colleague. She's very talented. But we are going to get started on our stories. But very quickly, I wanted to get to Foreclosure Defender's question is how you protect a script. A script is a work of authorship. It's something you wrote. So what you would be looking for that is a copyright. And what you guys need to know about copyrights is that now it is official. There's no more common law copyright. If you plan on really protecting your written works, your songs, your poems, your books, your scripts, your plays, you need to have an official copyright. You need to file it with the Copyright Office, okay? Foreclosure Defenders, I hope that answers your question. Okay? All right. So guys, we are getting started with our stories. And remember, you guys can submit stories too. Don't just leave it all up to me. I'm one person. I can only find so many. So believe me, I love when you guys submit stories to me. Okay? But we're going to start. And the first thing I want to let you guys know is that our fave Netflix is getting sued. Okay? So how many of you guys saw the Netflix, the Bandersnatch Choose Your Adventure? Hi, Daily Fashion Law. How many of you guys saw the Netflix movie that was like it was an interactive one called Bandersnatch? If you saw Bandersnatch, put a B in the comments. If you saw Bandersnatch, put B in the comments. And while you do that, I'm going to explain who the parties were. So this is a case of, hi DNAT7, this is a case of Chooseco versus Netflix. You saw Violet Wang, you saw Bandersnatch and hated it. Okay, I did not see Bandersnatch because I just wasn't interested. But if anybody else saw it, put a B in the comments. But and while you do that, let me explain who this case is against. So this is Chooseco versus Netflix. Chooseco they own a series called the Choose Your Own Adventure books. And I remember these books when I was growing up, they'd have them in the library. I wasn't particularly fond of them because I just didn't want to be flipping through all of those pages. King Tax Services, those aren't the issues that I cover, but we can talk about that on the side. Okay. If you don't know what Bandersnatch is, someone said I didn't see it and I don't know anything about it. Bandersnatch is a movie that is on Netflix. I think the full title is Black Mirror Bandersnatch, and it's a movie where you can interact with it. So it gets to certain scenes and you have to make decisions. I actually haven't watched it. But if you ever read the Choose Your Own Adventure books as a child or as a teenager, you may it's kind of like the visual version of a Choose Your Own Adventure book. And that's where the problem comes. Because Chooseco, the company that owns the Choose Your Own Adventure books, they own the rights. They own the trademark for the phrase choose your own adventure. Okay. And they are suing Netflix for trademark infringement and dilution of their brand. Okay. The reason why they are suing for both infringement and dilution of their brand is because what they're saying is Netflix, they have the trademark to choose your own adventure, and Netflix used a choose your own adventure book in the movie. As well, they're saying that the movie was really dark and it was gory, and they're like, that's not our brand. Our choose your own adventure stories are, kind of upbeat and adventuresome. They're not gory, they're not disturbing, things like that, okay? And when I talk about the book being in the movie, early in the movie, the main character tells his dad that Bandersnatch is a choose your own adventure book. So the main character is reading a book called Bandersnatch Choose Your Own Adventure. And they hold it up with a copy of this book with like a fake author's name. Okay. So Choose Co. is saying that Netflix is trying to capitalize off of the nostalgia of the Choose Your Adventure books of the 80s and 90s. Also, they're saying that because the movie was so dark and so disturbing, do they really have a brand? Give me 1 second. Give me 1 second, because that's a good question. They're saying that it dilutes the goodwill of their brand. And I was actually talking to someone about this, and they said they could kind of see how that would be, because what if you don't know anything about Choose Your Own Adventure books, but you saw Bandersnatch and the Choose Your Own Adventure in the movie that is very dark and very scary, and you don't buy a Choose Your Own Adventure book for a child in your life because you saw the Choose Your Own Adventure movie and thought, oh no, this is going to be too disturbing for a child. And that is a credible argument. I mean, if you think about it, right? That is dilution of the brand. Okay. Netflix, on the other hand, they're saying that basically Choose Your Own Adventure is just a way of telling a story, and you can't have a trademark on what is called a narrative device. Okay. They also said that they tell people that it's not from Choose Co. They tell people it's a Netflix film, and they want the case dropped. Choose Co. wants them to stop using the Choose Your Own Adventure phrase in the film because they themselves have a film in the works with 20th Century Fox, and they also have a board game that was released in 2018. So remember, same with the Muppets movie. You got some good, okay. Let me get through the facts and I'm going to get to your comments. So remember, trademarks you are for when you are using them to make money, right? So Choose Co. is saying we're using it to make money. We're about to come out with a movie. We have this board game that's out, and Netflix is saying that they're affiliated with us and they're putting out this dark, scary stuff. And we're afraid that it's going to dilute our brand. Okay. What kind of clinches it is that Netflix and Choose Co. were actually in negotiations to do a project together. Netflix is saying they never were talking about doing Bandersnatch specifically, just, in general, they were talking to Choose Co. about doing a movie. I don't know how much I believe that. And they're also saying that they are using the Choose Co., the Choose Your Adventure phrase satirically. And they're not like a parody. Remember, there's like fair trade, fair use. If you're doing it to be funny, if you're doing it as a parody to satire or social commentary, you kind of have some leeway in there. And that's Netflix's argument. Choose Co. is like, no, girl, that's our phrase. It's trademarked. They want $25 million or Netflix's profits, whichever is greater. And as well, they want treble damages. So remember, when you have a trademark or a copyright, if it's official and it's legal and you have to go to court, you have the option of getting treble damages, which means 3 times the actual damages that you suffered from the case. So if it's a $10 million case over trademarks, you could be owed $30 million for treble damages because of your legal trademark. So that's one of the reasons why you want to get your stuff on paper, because you want all your money. All right. If you remember last week, I talked about a case where the initial award was something like under $400,000. But because the other side was messing around and all this trademark stuff, it got upped to $3 million. So protecting your work is lucrative. All right. Yeah. So they are still in talks. We're going to see what's going to happen with Netflix and ChooseCo if Netflix is going to have to pay. But I want to get to Foreclosure Defenders comments. So Foreclosure Defenders said, do they really even have a brand? I think if you are someone in my age range, I think they do, because when I think Choose Your Own Adventure, I remember those books when I was growing up. I remember seeing them in the library. I knew the kinds of stories they were. I have not seen Bandersnatch, but from what I heard, it's very dark. It's very disturbing. I don't like those kind of movies. So if my first exposure to Choose Your Adventure was Bandersnatch, and then I saw Bandersnatch books, I know that for me, I would not think that it was child appropriate. Okay. And then I'm not sure what you mean with the Muppets movie. If you could expand on that. But if you guys have any questions about ChooseCo versus Netflix, please, let me know. Or if you don't want to ask them here, remember that you can always submit your comments and questions to nplconsultingfirm@gmail.com, and I'll answer them in chat with Nat on Tuesdays. Okay. Okay, so Foreclosure Defenders is going to come back. Next case, we want to talk about how many of you guys are Apple fans or have Apple products. If you have an Apple device, if you're an Apple fan, I want you to put an A in the comments. A for Apple. A in the comments. And while you do that, I'm going to tell you the facts of this story. Okay? So I don't know if you heard in the news, but there was all this talk that Apple had trademarked the term Air Power, but there is more to it than that. Daily Fashion Law. Okay, so he's an Apple fan, or at least has an Apple device. I've got an Apple device. I wouldn't necessarily say that I'm a fan of Apple. But here's what happened. So Apple did secure the trademark for Air Power, okay? But it's not because they filed it first. Here's what happened. Apple tried to trademark the term Air Power in 2018, but the trademark was already filed by a company called Advanced Access Technologies. Okay. Apple tried to file an opposition. And what that means is if somebody files a trademark and somebody out there believes that the mark they're trying to, secure is theirs, they can say to the USPTO, hey, I don't agree that person should have the trademark. I oppose that application. So that's what Apple did. They opposed Advanced Access Technologies trademark application. And they based it on the fact that they had a trademark on the terms AirPlay, AirPods, Airport, and AirPrint. Just sent it to me. Okay, I'm going to check it out in a second. AirPrint. After a while, I guess they were trying to push advanced access, and advanced access wasn't budging. They dropped the opposition. But so now they believe that what Apple did was got a license to use the trademark from Advanced Access, because now the lawyer who was the original lawyer for Advanced Access Technologies trademark application is gone, and now there's an Apple lawyer listed on that application. So when you kind of put the pictures together, Advanced Access Technologies and Apple most likely came to a a decision to license. And this is why when you trademark early, this is what you can do. Like, this is what some people are doing for a living. They're like securing trademarks and extorting people. This is not a case of extortion, but this is a case of why it's beneficial for you to trademark early. Foreclosure Defender said Sesame Street loses trademark lawsuit over Happy Murders films. Yeah, I definitely have to look at that, and I may have to, I'll either address it on Tuesday or we'll talk about it next week, because I want to get the facts and everything. But yeah, so Apple secured a trademark that they wanted, but not through the USPT, not because they own it. They had to license it out, all right? Muppets said Happy Murders was dark and distorted their brand. Yeah, the same thing like Chooseco and Netflix. All right, yeah, I want to sit down and read it so we can actually discuss it. Okay. Next case, y'all, we talking about my girl Cardi B. If you saw the title of the live, it says she didn't create it, but she's definitely making money from it. So we all know that Cardi B, she trademarked the term okurrr. However, Cardi did not invent this term. It was actually it actually started coming about by this woman by the name of Laura Bell Bundy. And apparently the Kardashians used to say it, and it can also be attributed to one of the contestants from a season of RuPaul's Drag Race by the name of Laganja Lestranja. Okay? However, Cardi B is the first person to make real money off of it. Remember, she was in a whole Pepsi commercial where they were all over the place, all right? And that's how she got it. And this is why, when I tell you trademarks are so that you can make money, this is what I mean. You can't take a trademark and then just sit on it. You need to use it, all right? So Cardi, she took the word and she used it and she made money from it, and now it's hers. Go Cardi. I salute her. All right, we're going to take a quick break. Just to introduce myself to people who may have just come in, I'm Natalie Pierre-Lewis. I'm the owner and operator of NPL Consulting LLC, a business formation firm. What that means is I help you get your business paperwork together. Getting trademarks, contracts, articles of incorporation, making sure your business is legit is my business. If you are interested in any of my services, hit the link in my bio, schedule a free 15-minute consultation, and we can get it popping. All right. As well, if you are in the live today, and I will be able to tell, after I leave, I have a special deal for you. My Protect Your Biz video training bundle, where it's a 2-hour seminar on patents, copyrights, and trademarks. It is usually $79. If you are in the live stream today, you can get it for $35 as long as you DM me your email address. All right? All right. So now on to the next story. My ladies in the room, how many of you guys like MAC Cosmetics? If you like MAC Cosmetics, put an M in the comments for me. MAC Cosmetics. I myself, I like MAC. I still use MAC, but for my foundation, I've switched over to Fenty because it's just a lot lighter on my skin. But if you like, okay, Ivana is a MAC fan. Foreclosure Defenders is a MAC fan. Well, guys, MAC has won a trademark infringement lawsuit in China. Okay, lawsuit in China. So there is a company in China called NetEase, and they have an e-commerce platform called Kayola, and they were selling knockoff MAC cosmetics. So the big thing about this story is that China doesn't usually side with foreign countries or foreign companies in trademark cases, but I want you guys to go Google this. The MAC trademark case in China, they were using the same lettering, the same colors, the same images, and they had no license from MAC. So China said you're infringing on their mark, and this company has been ordered to destroy all of their inventory that has any MAC labeling, anything on it. So having a trademark gives you a lot of power. It can prevent people from importing stuff into your country. You can stop people from making things. If you remember when I talked about the Barbie case, they shut down the whole Bratz empire because of Barbie trademarking, guys. All right. So Mac girls, Mac is out there defending the brand. Next story we are talking about. How many of you guys are into home remedies? Like, you know, your mom's like, put this in that, make a tea. If you do home remedy, did MAC Cosmetic? They do have a global trademark because the arm of their business that sued was the arm that was based in China. But they're an American company. But, you know, they have offices all over the place. And they probably have people out there scouring because you have tons of people out there selling knockoff cosmetics. Okay, Ivana, if you're interested in the patent class, DM me your email address and I will send you the $35 deal because it's not a deal that you can find on my site. I have to send it to you directly. All right? Okay. So, how many of you guys are into home remedies? If you do home remedies like, you know, teas and steams and whatever, give me an H. Send me your email, Foreclosure Defenders. If you're into home remedies, give me an H. 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 And while you guys let me know if you do home remedies or if you just go to CVS and grab a couple of pills. Here's the case. Okay, I got two people who like home remedies. So there's this company called Shire City Herbals, okay? And they trademarked the phrase fire cider in 2012. So they had it for about 7 years, right? And they sell vinegar-based health tonics. They filed a $100,000 lawsuit against this collective called the Fire Cider 3 for use of the name. They sent them a deceased letter and they didn't listen and they're like, well, we're suing you. Okay. So here's the deal with Fire Cider 3. All of them run herbal based businesses, right? So, you know, they'll sell you like loose teas or tonics and things like that. And they say that the herbal community has been using the term fire cider for over 40 years. So it's a common word and that it can't be trademarked. That's their argument. They said that it was started by the godmother of modern herbalism, whose name is Rosemary Gladstar. Okay. She said she used it in a home study course when she was teaching. And while the term was copyrighted in a book she wrote, that was published by a real publishing company in a book. But they're just basically saying it's a generic term. You can't trademark a generic term, okay? In the meantime, the herbal community has boycotted Shire City Herbal. They filed a notice with the USPTO to have the trademark canceled. They are mad. They are big mad over fire cider. Okay. But Shire City, they're saying, look, we trademarked this 7 years ago. It's not like it's new. And they've tried to negotiate with the Fire Cider 3 for a year and a half, and it just hasn't worked. So I want to know from you guys, have you guys ever heard of the term fire cider? Because for me, I never heard of the term fire cider before this story. Have you guys ever heard of the term fire cider? Because I try and think about it, and it just seems like a term that is used in a very small community. Hi, Pink Nior. And it reminds me of the Disney case with Hakuna Matata. So, you know, we all love The Lion King and Hakuna Matata, the song, and it was great. But for the most part, the American audience didn't know what Hakuna Matata meant or that it existed before The Lion King. But just recently, in the last year or so, there's been this big pushback because Hakuna Matata is actually a very common phrase in Swahili, and Kenyans are up in arms about it. right? So I have to think. And for me, I understand the outrage over Hakuna Matata, but does the same thing apply for this fire cider? So Ivana never heard of fire cider. Okay, so it's like, so we have to wonder, what is generic? Is it generic in the community? Does it have to be generic overall? What counts as generic? And this is why the law can be tricky, because you have to really define the words carefully. It's like, what does on mean? What does in mean? I remember there was this case in law school that we studied where it was a DUI case, and the law said that you were considered drunk if your blood alcohol level was between two numbers, right? D-Nat never heard of it either. This person, their blood alcohol level wasn't between, it was at the very end. So let's say it was 8.0 and it was like 0.08 and 0.112. He was at 0.08. So his attorney argued that it wasn't between 0.08 and 0.12. It was at 0.08 and he won. So this is why words are important, okay? All right. So let us go to the next story. So I think the fire cider argument, I think it's kind of weak, because outside of the herbalism community, and even people who do home remedies, I feel like enough of us these days do home remedies that fire cider would have been a common term. And I don't think it is, but that's just my opinion. Next story. I want you guys to give me an L for Legos. If you have ever played with Legos, seen a Lego, know what a Lego is, watch the Lego movie, give me an L for Lego. Lego. Because Lego just won a case. Oh, I got 2 cases about China today. Lego just won a case in China. Okay. They got I got 2 L's. They got a company's trademark canceled in China. Okay. So here's what happened. Basically, this company, I got 3 Legos. This company named Lepin, Lepin, was basically selling fake Legos in China. Okay. Lego found out. They sent a cease and desist letter to this company, and they were like, hey, we own the trademark to, this design and everything. And the Chinese company Lepin basically said, well, show us proof that, that you dominate this, block market. So Lego sent all the receipts. They said, here's how much money we've made. Here's our coverage. Here's everything, right? After they sent all that, how when you tell somebody tells you to prove it and you prove it and they shut up? That's exactly what Lepin did. They were like, well, they said nothing, and they basically left it in the hands of the court. Hi, Creative Chrissy. Hi, Delbo Wonder? Yeah. So basically, once Lego showed that they do have market dominance, Lepin said, well, tell it to the judge. So the judge agreed. And they said that because they said that the pictures of the Lepin blocks looked just like Lego. And they even had a Lego set that was based on The Simpsons, which means that they probably didn't have a license for that either. So the court, not only did Lego get damages, but the court also awarded them court costs. So Lepin had to pay all of the attorney's fees for Lego. So this is why I say that having your trademarks in place is really important. It's very lucrative. You can get a lot of money. If you want to know more, send me your email and you can get my Protect Your Biz training bundle for $35 instead of $79. I break down patents, copyrights, and trademarks in 2 hours. You can get that for $35 if you send me your email address. Okay. But that's the end of Lego. So next story, we are talking about my ladies in the room. How many of you guys have ever shopped at Ulta? If you have ever shopped at Ulta, or my gentlemen in the room, you may need to go, for some skincare products. If you have ever shopped at Ulta, please give me a U. Put a U in the comments because we are Ulta stealing, guys. If you've ever shopped at Ulta, give me a U. Okay, Pink Nior has shopped at Ulta. Okay. Creative Chrissy has shopped at Ulta. DNAT, I'm going to assume that was supposed to be a U, DNAT. It's right next to, okay. Okay, cool. So y'all shopped at Ulta. So here's, Ulta is being sued by an Amsterdam artist by the name of Dominic Sebastian Metcalf. So here's what happened. I'm going to show you, let me see if I can show you the picture. So he said that Ulta took a picture of one of his paintings. He's a very famous artist. He's worked with companies like Puma, Nike, and Chanel. So he's not just like, you know, a starving artist trying to make a buck. His work is well known. He said that Ulta stole his painting and put it on the packaging of their face masks, right? So I don't know if you guys can, how well you guys, maybe if I turn off this light, it'll be better. I guess not. Anyway, if you can see, so here is his painting. Here is the face mask package. Facebook, here's for you guys. It's a little clearer on Facebook. This is the painting. This is the face mask package, right? All right. So basically he said that they took his painting and they used it because he puts his work out on his Tumblr and on his website. And the only way that they could have accessed it was to go on his Tumblr or his website, okay? The picture, it's a two-dimensional series called Holographic Melt. To me, it looks like when you take a picture of your computer screen and you get those squiggly lines, but without the actual picture in the back. To me, it just looks like the squiggly lines. Hi, Brittany, how are you? Okay. So the Ulta took the mark and used it to sell the Brightplex unicorn masks. So if you guys have ever gone to Ulta and used the Brightplex unicorn masks, or go to Ulta, go look at them, the original artist of that packaging is suing Ulta over it because they didn't get permission. The artist, Dominic Metcalf, he told them to stop, and what they did was they just kind of changed it a little. They tried to alter it a little. However, while you can alter original logos, you can't take somebody else's work and then do a little change to it and then say, whoa, it's not yours. You know, like, anyway, so he's the problem with here is, remember I told you guys, in the United States now, if you don't have a legal copyright, you can't go to court to defend your work anymore. You have to have a registered one. But he is saying, I am not an American citizen, so I am not beholden to that rule, okay? And I shouldn't have to follow it. So he wants Ulta to stop using his image on their face mask product, and he wants them, and he wants money. He's also apparently sued Katy Perry and some K-pop group for using his work as well. So Mr. Metcalf is protecting his stuff. And this is why I'm saying that you have to be vigilant when it comes to protecting your intellectual property. The USPTO is not going to do it for you. The Copyright Office is going is not going to do it for you. Maybe the people who support your brand might tell you, but it's up to you to do the work to protect your stuff out here in the world, because there are people out here ready to steal. Okay. All right. Next story we are talking about. How many of you guys have shopped at Macy's? If you have shopped at Macy's, you ever walked into a Macy's, we've already done M. I want you to give me an O, because this is actually involving a company that works with Macy's called Olivet. So if you have ever smelled, hi Chris Lynch, smelled, seen, gone into, shopped at, been in the vicinity of a Macy's, I want you to put an O in the comments. All right. Okay. Thank you, Creative Chrissy. Thank you, Pink Neor. All right. So here is the issue. There is a luggage company that is the Away luggage company. They are suing this company called Olivet and Macy's. Now, Olivet, thank you, Ivana9572. Olivet, they are a company that licenses luggage for a lot of brands. So they basically will, you know, they'll create the luggage, or they'll get a license from someone and they'll just do all of these different lines for different companies, okay? They're the source for this luggage. The Away luggage company was started by executives from Warby Parker. And if you guys know Warby Parker, they're that company where you can order, you know, frames to your house, like 5 of them, and you can test them out. They have like some physical stores. Where I am, there is a physical store in DC. Anyway, the executive started this company called Away, and they were in talks with Olivet, because Olivet hit, you know, contacted them in like August of 2017 to talk about doing a collaboration. Now, when they went into that talk, they all signed NDAs because they had to reveal, you know, how their luggage was made, what are the materials, what's the process, things like that, to see if Olivet could replicate it. Okay. They were in talks, but in October of 2018, so they had been in talks for over a year, they decided that they weren't going to go through with the deal with Olivet because the tariffs, meaning the taxes on suitcases and raw materials, were too high at the time, but they wanted to come back to it in March of 2019. Okay. Fast forward to January 2019, they find out that Macy's has been selling these look-alike suitcases by Olivet. Okay. Now, these Away suitcases, according to the executives, they say that they have had media attention. They have celebrity fans. They've got over 2,000 stories in the news. They have a signature look, and it's eligible for a trademark. And I'm going to show you what the suitcase looks like. So, okay. So here again. This is the Away suitcase. This is the Olivet one that was being sold at Macy's. Facebook, here you go. This is the Away suitcase. This is the Olivet suitcase that was being sold at Macy's. And then there's another photo. This is what they look like on the side. Practically identical. Okay. Okay. So, Away showed that there was social proof, meaning that there is evidence out there that people associate this bag with our brand. Okay, and even further, somebody bought the bag at Macy's, the Olivet bag, and then called up the Away company to activate the warranty. And Away was like, "You did not buy it from us." Okay, so they're saying that Macy's is and the reason why they're suing Macy's along with Olivet is because Macy's gives Olivet a lot of work, and they were basically egging them on to do this luggage line for them. So there has not been a resolution yet. So we're going to see what happens in the future. And I will keep you guys posted on what happens with that. If you have any questions about the case, again, you can always email me at nplconsultingfirm@gmail.com, and I will answer it in the new Chat with Nat on Tuesdays. Okay. Oh, I don't know if you guys saw my IG stories this week. We're moving on to another story. But I read a story where it said that the NCAA was trademarking some new terms. And, you know, me being nosy, I did my little research and I went and I found out that the NCAA, the people who do March Madness, the basketball, they own 72 trademarks. 72. And I bring this up because I watched the news in the morning, and NCAA, they break in billions of dollars, and there's been this ongoing argument as to whether NCAA athletes should be paid. And for me, in my mind, if you're putting all this money into getting trademarks, because trademarks are not cheap, why can't you provide a stipend for these players whose backs you're making money off of? Yes, they get a free education, but they also have to, you know, they lose time with their families. They can't study what they want because they have to work their study. Hello, Smoke Signal Entertainment. They have to work their class schedules around practice instead of the other way around. So if the NCAA is going to all the trouble of trademarking these 72 trademarks, you tell me you can't break these kids off a little stipend monthly to, you know, live their lives in school and be able to just get things done? Anyway, I thought it was just an interesting snippet. Thank you to all of you who just joined in Facebook land. I've been getting a lot of love from you guys the last week or so. Thank you to Brittany for being amazing. And for those of you who if this is your first time with me, every Thursday I get on here. I talk about pop culture stories and the legal issues behind them, particularly having to do with business and how you can use them to protect your assets. Okay. Again, if you are in the live stream today and you want access to my Protect Your Biz training bundle, which is a 2-hour seminar on patents, trademarks, and copyrights, DM me your email address and you can get it for $35 instead of the regular $79. Okay. And if you don't know my name, Natalie Pierre Lewis, owner of NPL Consulting LLC, a business formation firm. I help you get your business paperwork together. I help you get that infrastructure together. So if you need trademarks, contracts, filing your articles of incorporation, knowing how to hire employees, that is what I'm here for. My business is making sure your business is straight, okay? But we are coming up on our last couple of cases for tonight. If you came in late, please go back and watch the beginning. We talked about so many things, had a great time. Last two cases we're talking about. First one is it's not a laughing matter, but it has to do with comedy companies. So there is a company called Funny for Funds, and they are suing another company called Treehouse Comedy Productions. Okay, Funny for Funds, they offer comedy night fundraisers. So yeah. Oh, I forget to tell people. I'm a licensed attorney. I'm not just talking out of my butt, guys. I went to school for this. I graduated from Suffolk University Law School, if you want to know. Anyway, back to the story. Funny for Funds offers comedy night fundraisers, okay? So I'm sure you guys have at least heard of them if you have not attended. They've raised over $4.2 million for charities, okay? Now, Treehouse Comedy Productions, they have been using, or this is what Funny for Funds claims, that Treehouse Comedy Productions has been using the Funny for Funds mark in their shows to deceive customers into thinking they were watching a Funny for Funds production. Apparently, Treehouse Comedy Productions labeled over 40 events with Funny for Funds, okay? They had apparently contacted Funny for Funds before and said that they wanted to use the mark, but they never signed a licensing agreement. Now, remember, you can't just go and use people's marks. I'm going to tell you guys a story. So today, I was in one of my Facebook groups, and I'm in a few crafting groups. And someone posted a picture of some, brand name slides that a customer wanted them to do, make a replica of. And she was like, I don't know if I can do this. And my answer is a resounding no. You can't just take somebody's mark and use it on your stuff, guys. It's illegal. You can get sued. You can lose money. If you want to use somebody's mark, if it's that serious to you, get a license with the company. And if you can't do that, then just don't use it. Make your own. You don't want them troubles because they have long money. They got long legal money and you don't want to get in trouble. All right. Anyway, so Funny for Funds, we're going to wait and see what happens between them and Treehouse Comedy Productions. But I'm pretty sure Treehouse Comedy is going to have to come up off some money because they held 40 events, over 40 events with the trademark of this company. And when you have an official trademark, you can get your damages. Funny for Funds can say, look, that money that you made off those shows, we could have made that for charity. We want it all back, plus 3 times what we lost because you did it on purpose. So, again, trademarks are important. If you want to learn how to protect your stuff, DM me your email. You're going to get my Protect Your Biz video training for just $35, okay? And the last story that we are talking about, guys, how many of you guys heard about that school admissions scandal with Felicity Huffman and Lori Loughlin? If you heard about the scandal, I want you guys to give me a star. If you heard about the school admissions scandal. Hi, I am Sunshine Speaks. If you heard about the school admissions scandal, give me a star, because they are not having a good couple of weeks. And while you guys do that, I'm going to, okay, I got a star from Creative Chrissy. So she heard about it. If you didn't hear about it, basically celebrities have been buying their children's way into schools, probably taking spots away from children who academically deserved it. Okay. And one of those people was Aunt Becky from Full House, guys. I remember watching Full House every day. Thank you, Pink New York, for that star. Thank you, I am Sunshine Speaks, for the star. Anyway, Aunt Becky's daughter is in some more trouble. If you know, she withdrew from school. She's supposed to be, thank you, Whitney Hand, for the star. After the scandal came out, she withdrew from school. But what I didn't know prior to the story is that Lori Loughlin's daughter is actually a big social media influencer, and she has a lot of products. And apparently she filed some trademarks and she's about to lose them because of poor punctuation. Olivia Jade, Aunt Becky's daughter, well, I shouldn't say Aunt Becky, Lori Loughlin's daughter, applied for the trademarks Olivia Jade Beauty and Olivia Jade. Okay. And now they're saying that the applications are at risk of abandonment. And what that means is, okay, so when you apply for a trademark, it takes about 6 months to hear back from the USPTO. Then in that time, you have another 6 months to get back to them. If you don't get back to them, your application is considered abandoned and you don't have the trademark. They're just like, well, they don't care. So no application for the trademark. Okay. So, hey, New Haitian. So they are considering abandoning Olivia Jade's trademarks because, one, she was too broad in what she was trying to trademark. She said that she wanted to trademark makeup kits, moisturizer, and concealer. Now, what does makeup kits mean? It could mean eyeshadow. It could mean lip gloss. It could mean, a concealer palette. When you are filing a trademark, you have to be very specific about what you are trying to trademark in, the industry you are trying to trademark in, because you can't be overbroad. They're not going to accept that. Okay. So if she needs to say, I want to do eyeshadow makeup kits, whatever it is, or moisturizer. Is it anti-aging moisturizer, organic? Like, you need to be specific. Moisturizer is too broad. Is it body moisturizer? Is it face moisturizer? Okay. And the second reason why they're about to cancel her trademark is because of bad punctuation. Guys, punctuation matters when you are trying to protect your work. You can't spell something one way on your trademark application and then start using it in another spelling, everywhere else. Trademarks are very, very specific. So you need to be very sure when you're filing for your trademarks or your copyrights that this is what you want to protect. Don't waste your money protecting something if you feel like you're going to change the design 6 months later. Just if you know that this is the name, the phrase, or the logo design that you're going to use, yes, protect it and don't change it, because that confuses your audience. Okay. and it confuses the USPTO. So if you, let me, what's an example? Okay. Let's just use her, Olivia Jade. So let's say instead of Olivia Jade, how she spells her regular name, she started spelling Jade, I don't know, stick a Y in there somewhere. That would not be the trademark that she filed under, so it would not be protected, okay? So if you file for a trademark, when you're protecting or when you're trying to protect something, you can't have all these, crazy variations. If you're going to have variations, you need to file trademarks for each one. So going back to Cardi B, she filed trademarks for okurrr, right? She filed for one that has 3 R's and she filed for one that has 2 R's because you can't just go and change the spelling. They're not the same. Okay. All right. Also, Olivia Jade, she has lost out on a lot of partnerships with Sephora since this scandal. So chicken's coming home to roost. All right. So yeah, those were all of our stories for today. Again, guys, if you have questions, if you have comments, please drop them in the comments and I can, get, what time do we have? 6. Wow, it's 6:56 already. Okay. So I want to keep this under an hour just so Instagram doesn't lose out. But, if you have questions, drop them in the comments. If we don't get to them today, remember, email me, nplconsultingfirm@gmail.com, and I will answer it on Chat with Nat Tuesday. I will record a video responding to your letters and you guys will be able to watch it, okay? But what I really like is interacting with you. So if you guys like this, come back every Thursday. Let's chat. Facebook, thank you so much for your participation. This is like the most participation I've ever had from Facebook since I've been here. Y'all are dope. Brittany, you're so dope. If you are in the live stream and you are interested in protecting your ideas, your designs, I know I have a lot of crafters in the room today. You're going to want my Protect Your Biz video training. DM me your email and you can get it for $35 instead of the $79. This is a private deal. I'm not posting it anywhere. You have to send me your email so I can send it to you directly because I don't want anybody else taking advantage because y'all were here, you are participating, and I want to give you an award for that as well. Make sure you download my free trademark toolkit so that you can have some tips on protecting your work until you can get it officially registered. Check out my my podcast as well. I'm a big podcast lover and I love to interview entrepreneurs and set up your free consultations, guys. I give free 15-minute consultations to first-time customers. So if you want to knock around some ideas, go to the link in my bio, click book your free consultation, and let's chat, okay? We got 3 more minutes. I'm still waiting for some questions. What's going on, guys? Do you have any questions about our stories? About what are the stories we covered today? For those of you who came in a little later, the stories we covered today are that Netflix is being sued by the company that owns the Choose Your Own Adventure brand. Apple got the trademark to Air Power by getting a license for it from another company. Cardi B trademarked okurrr, but she didn't create it. MAC Cosmetics won a trademark infringement case in China. There is a big kerfuffle in the herbalist community over fire cider. What else? Lego got a trademark canceled in China because somebody was selling fake Legos. Macy's is being sued for trademark infringement for fake luggage. We talked about the comedy and Olivia Jade. So guys, if you have any questions about those, I'm here. Again, you can also email me, nplconsultingfirm@gmail.com. Go to the link in my bio, linktree/consulting firm, linktree/NPL consulting firm, linktree/NPL consulting firm. Hit me up. Let's talk. I want to hear from you. Okay. So Ivana, Tuesdays are when if you have questions, I will record a response and post it. So that's what Tuesdays are going to be about. Okay. So again, hit me up, respond, DMs, email, and I will respond and chat with Nat on Tuesdays. I think Instagram is about to time out on me. So guys, I'm just going to peace out right now. I will see you next Thursday. Thanks for participating. This was great. I'm so happy. Bye, guys.